Well, good morning, everybody, and welcome to the Kane, Shannon, Weiler Employment Business webinar this morning. We appreciate everybody's attendance. My name is Michael Weiler. I am the Senior Associate Counsel and a member of the Employment and Labor Group at Kane, Shannon, and Weiler. I moved my practice to my brother's firm in October of 2019 and to work with Chris and the others within the group. Chris Drinovz is the group chair. Chris has outstanding academic credentials and has a strong connection to the business communities south of the Fraser. And through Chris's direction, we've been able to expand our group, adding two new associates, Junkie and Ali, who are on the call today. So we're now up to 6 lawyers in our group, and I think that reflects the growth within the business community south of the Fraser. Darlene Dort is with us today. Darlene is a senior solicitor with KSW, works out of our Surrey office. Darlene's practice includes all aspects of business law, real estate, wills, estates, and trusts, and other commercial transactions. Darlene has taught business law course at Simon Fraser University and has been a guest lecturer for the Law Society of British Columbia for a number of years. Anna McAuley is the group's administrator. She provides valuable support to Chris and I and others in client development initiatives, web page design, content, and of course doing the administrative work that's been able for us to put on these webinars. I should say that in addition to the uncertainty created by Donald Trump down south, we had a bit of uncertainty as I was getting ready. All the electricity in our building went out, so it just came on. So if I'm breathing heavy, it's because we were trying to sort this out. Banana was able to get us sorted out and set up here. So
basically, the material we have is quite extensive. So one of the things we're not going to do today is the fourth item that we talked about, which is the how to deal with layoffs and terminations in a COVID world. We will take any questions on those and deal with those later. When we prepared this seminar, I was thinking that what lawyers try to do is we try to certainly be up to date on the law, know the law, and that allows us to ask questions. And when we then know the areas to ask the questions, we can work with the client, get the facts, and then provide the advice that you need to move forward. And so similarly, we hope that today's seminar, even though we'll be looking at a lot of these topics at 30,000 feet, will allow you as business managers and HR specialists to be able to examine any particular problem you have or potential problem and ask yourself what questions you have that may require you to think about how you're going to proceed, especially wanting to be cautious with troubled employees. I mean, my experience is that 5% of the employees cause 95% of your problems. So you should be able to identify where there may be a problem with an employee. So that's what we're trying to get out today, is an overview of these very detailed areas. From my point of view, employees are your most valuable asset, and it's worthwhile to learn how to manage the employment relationship in a way that preserves those assets and maintains a very positive and productive relationship with your employees. As far as questions and answers, if you hit the QA function on your screen at the bottom and send the questions, we'll be able to either answer them at the end of the presentation, or we will follow up with any questions that are asked that are not answered on this presentation with an email response to you, and where appropriate, we'll post those questions and answers on the webpage. I should also point out that we are recording this session and that we'll post that recording on our website as well for anybody that missed something that came on. Now, as I say, questions are really important. But when your lawyer says, no, that's an interesting question, that's usually when you got to run for the checkbook. So what we'll do again today is probably raise a number of interesting questions. If you can examine your particular circumstances and maybe head off problems down the road, you'll find it of use. So what we're going to do is start with Chris is going to talk about the WorkSafe issues that we've discussed. And then we're going to move to succession planning and employee buyouts that Darlene's going to speak to. And then I'll finish up talking about a human rights update in a COVID world, including the duty to accommodate. So with that said, I'm going to turn it over to Chris, who will discuss the really significant WorkSafe issues that are presented.
Great. Thanks very much, Mike. I'm very happy we're able to sort out the power issues and get you on today, because I certainly wasn't ready to give an introduction. So big relief there. So I'm going to talk a little bit about the Workers' Compensation Act. I've been practicing in this area for about 10 years, and with the NDP winning the majority government in the recent election, changes that have been in the works for some time are going to come to bear in the coming months and years. So for this reason, understanding employers' obligations under the Workers' Compensation Act has never been more important. I'm not going to go into a full history of workers' compensation and how it came to be, but in essence, it's a system of compulsory no-fault insurance that's administered by the government. Its origins go back to the 19th century, to Germany, actually, and it was introduced in the United Kingdom and the United States. And in 1910, Sir William Ralph Meredith, who was the then Chief Justice of the Ontario Court, proposed the system be adopted in Ontario and ultimately in Canada. And the whole system is based on what's known as the historic trade-off or historic compromise. And basically, this historic compromise is workers lose their ability to sue the employer or their fellow workers in court for injuries that occur in the workplace, but they gain a compensation system that depends neither on the fault of the employer nor its ability to pay. So it's an employer-funded insurance scheme. So similarly, employers are forced to contribute to the mandatory insurance scheme based on their payroll, but they gained the freedom from potentially crippling liability to pay for the negligence of workers and the injuries of workers that occur in the course of employment. So an employer's quarterly premiums for WorkSafe are determined by looking at two things: looking at the firm's assessable payroll and multiplying that by the firm's premium rate. And the premium rate is calculated in two ways. First, it looks at the base rate, which is kind of the rate that applies to every employer in a specific industry, and that looks at the nature of the business, which an employer can't do anything about. It is what it is. But WorkSafe also looks at the employer's experience rating, and it applies that experience rating to give a net premium rate. So an experience rating looks at the average claims costs for that particular firm. And if you have less claims or less expensive claims on average than the other people in your category, you can have a discounted net premium rate and therefore lower premium costs. If you have higher claims or more expensive claims than average, your premium can go as much as 100% higher, so it can double, which can effectively double your WorkSafeBC premium costs. So for that reason, employers have an interest in understanding and managing WorkSafeBC claims, because it does ultimately go to the bottom line. So since 2018, the BC Labour Minister, Harry Bains, has commissioned no fewer than 5 comprehensive reports reviewing the employer-funded compensation system. And these reports are not small endeavors. These are lengthy, comprehensive studies done by various industry experts and with significant consultation from stakeholders. Now, there's been varying degrees of participation from the business community in these studies, which I'll talk a little bit more about. But at KSW, we have the privilege of being part of a group called the Employers Forum. And basically, it's a group that lobbies and represents the business community in relation to WorkSafeBC changes. So through our participation in that group, we're able to get some great insights into changes that are coming, and we're able to participate with the big players in the business community in determining how those changes are rolled out. So I'm not going to review each of the 5 reports in detail. We provided some links to the reports for you to review on your own time. But I'll go through them briefly in chronological order. The first report is called the Petrie Report. It's from April in 2018, and Paul Petrie was a former vice chair of Workers' Compensation Appeal Tribunal, and the report is called Restoring the Balance. And the title itself is kind of telling. Clearly, the report is aimed at providing more benefits for workers and restoring what was perceived as an imbalance in the system that the Liberals had brought in that favored employers and business and capital. There were 41 recommendations made in the Petrie report to provide a more worker-centered approach to the system. These recommendations have not been implemented in full at this time, but they were influential in the recent amendments to the Workers' Compensation Act, which I will get to shortly. The second report was called the Bogio Report, and this was done in December 2018. This was a report by Terry Bogio, who was a longtime WorkSafeBC senior advisor. And the purpose of this report was to look at what are the options for spending the $3 billion surplus that had accumulated in 2008. Now, in May of this year, Minister Baines made an announcement that the surplus had all but vanished because of the economic decline after COVID and the impact of that on WorkSafeBC's investments. We don't have the full details of that. We don't know if that's actually the case. And it's not clear at this time whether some or all of that surplus has since been restored due to the markets recovering. But in his report, Terry Bogio reviewed 9 options for using this $2.6 or $3 billion surplus. And I won't go into all those options today, but again, those options were influential again in some of the changes that have been implemented in the new amendments this summer. The next report was called the Helps Report. It was from August 2019, and it was prepared by Lisa Helps, who's a criminal defense lawyer in Vancouver. This report was specifically responsive to 2 sawmill explosion incidents where there were fatalities in British Columbia. And she looked at those incidents and WorkSafeBC's response through a health and safety lens. And she made 11 recommendations relating to workplace health and safety, most of which created more significant liabilities or penalties for employers or more onerous obligations for employers in relation to health and safety. And health and safety regulations and provisions are often much easier to push through the legislation because safety is important to both the employer and the worker. And so many of these recommendations made their way into the most recent amendments to the Act, which happened this summer, and I'll go through in a moment. The fourth one is called the Parr Report, and it was from February of 2020. And this was prepared by Jeff Parr, who's the former Alberta Deputy Minister of Labour and is now the chair of the WorkSafeBC Board of Directors. So again, he's an industry expert, and the purpose of his report was to essentially look at the 3 previous reports and determine which recommendations and options were appropriate to include in amendments this year that the government was planning to make. So he made 14 recommendations for amendments to the Workers' Compensation Act, and many of those were in fact implemented. And so one of the comments on the Parr report was, this report the research was done, pre-COVID. So when the $3 billion surplus was there, there was economic stability, and there was a reason to think about increasing worker benefits without really penalizing employers or having to take money out of the accident fund. We could use the surplus to bring in some of these ideas that Petrie had envisioned a couple of years ago. Of course, COVID happened, and the economy grinds to a halt. Businesses are shutting down, and the NDP decided nonetheless to go ahead with the amendments and to implement a lot of these recommendations, some of which are potentially going to create significant costs. So there was a massive protest and resistance from the employers forum and the business community when Minister Baines announced that they were going to go ahead with these amendments. There was a strong letter sent by the employers forum, but it was effectively ignored. and the amendments went through. So we now have an amended Workers' Compensation Act. So I'm going to review some of those amendments here. The bill was introduced in July of this year. It was passed into law in August. And at this stage, I think it's important to note that these amendments are stage one of probably 5 stages that we're going to see. And these amendments are actually quite conservative compared to some of the ideas that we saw in the Peacher report and some of the ideas that we're going to go through in the 5th report, which is called the Patterson report. But what I'll do is I'll give a brief summary of the key amendments that have come into force now, and then I'll look at what's potentially to come. So one thing that was changed is they've increased the maximum insurable earnings from 87,000 to 100,000. So the idea behind this is there's a statutory ceiling to the total amount of benefits a worker can receive. And so it used to be 87,000. So if your worker was earning 100,000 or 150,000, their benefits would be based on that statutory cap of 87,000. This has now been increased to 100,000. And the idea is, wages have increased over the years, and we don't want to be, paying out less than workers' salaries if they're, earning 100,000 or more. Secondly, and very significantly, there's been a change to the assessment of pensions under the Act. So currently, the default way to assess workers' permanent disability pension is using what's called the loss of function method. And that method doesn't look at the workers' lost wages that they would have pre-injury and post-injury. It looks at the level of impairment they've suffered from the injury. And that's done through a functional assessment. And there is a process where the WorkSafe officers will assign a percentage of disability to the worker. So they might be assessed to be 5% impaired from working at their full capacity, or 10% impaired from working at their full capacity. If that's the assessment, then that worker will be entitled to a pension that's based on 5% of their earnings or 10% of their earnings, up to the age of 65 or whatever the retirement age is deemed to be. It's only if the worker suffers what's called a significant loss of earnings between the pre-injury situation and the post-injury situation that WorkSafe will consider a second method of assessing the pension, which is called the loss of earnings pension. So generally speaking, so long as the earnings between the pre-accident scenario and the post-injury scenario are not significant, employers are not being faced with these loss of earnings pensions, which can be much greater than the loss of function pensions. The rule change now is that WorkSafe is going to do an assessment of both pensions, both the loss of function and the loss of earnings, and whichever is higher, the worker is going to get. So it doesn't matter if the difference is significant or not. They're going to do the 2 assessments, and the worker is going to get the better of the 2. So ultimately, this is going to lead to higher pension awards and greater claims costs for employers. Another change that's significant deals with the setting of a retirement age. So presently, the default age for retirement is 65, and that basically sets the date where the WorkSafe benefits will stop, where the coverage will end for these permanent disability pensions that I mentioned. So presently, the worker's retirement date is set at the time that the pension is assessed. So that's usually shortly after the injury or at the time that the injury settles down into a permanent condition. So for a young worker, that might be when they're 30 or 35, and the board will set their retirement date at that time, which many perceive as unfair because who knows when they're going to retire when they're 30 or 35. It's very difficult to present evidence that you're going to work later than 65 when you're only 30. And so there's a lot of cases where the default age of 65 is being set, and people don't really have an opportunity to present evidence that they were intended to work later. So what they're going to go to now is they're not going to assess the retirement age until the worker is actually close to the age of 65. And so the retirement age is going to be left open. And when the worker gets closer to retirement, like age 63, the board will do an assessment and look at is it likely that they're going to continue working past 65? And ultimately, we think this is going to result in more claims going past the age of 65, and again, higher claims costs. So that these two changes with the pension and the retirement age are going to come into effect in January of 2021, whereas all the other changes have come into effect now. Some other important changes. As of now, before you can access healthcare under a claim, a worker needs to have that claim accepted by WorkSafe. So some entitlement officer needs to have made an adjudication and assessment of whether the injury was work-related. The worker then becomes entitled to the funded benefits such as treatment and wage loss. The change they're making is in urgent healthcare situations. They are going to provide healthcare such as treatment, counseling, those types of things when it's urgently needed before they've actually accepted a claim. And so this creates an issue of what happens to those costs if the claim is ultimately denied. Is the employer still on the hook for those costs, or should they properly be switched over to the public health system? So that was one of the issues raised by the employer community when these changes came in, and it looks like the employers are going to be stuck with those costs, even though they're not necessarily related to a work injury. Another big change is currently there's a 1-year limitation for somebody to report a work injury, and if somebody misses that 1-year deadline, they have to show that there were special circumstances that existed that prevented them from making the report. So in a case of, say, PTSD, they might be able to say that they were sufficiently impaired by their symptoms. They weren't able to seek the advice they needed to make the claim, that kind of thing. But it's a fairly high burden to explain why you didn't make that claim within a year. And it actually prevents a lot of those claims from coming in. The change that's been made here is that 1-year limitation is going to be gone. So in specific mental health claims, workers aren't going to be held to that deadline. And our anticipation is that this is going to again result in a lot more mental health claims and higher claims costs. There's a couple other things that I won't go into. As I mentioned before, the HELPS report talks about health and safety changes and recommendations. And so a lot of those were implemented in these new changes as well. There seems to be a bit of a shift from dealing with health and safety violations in an administrative way through fines and penalties to potentially dealing with them in a criminal or a quasi-criminal way, which of course is concerning to employers. So WorkSafe has been given some more procedural tools to lay criminal charges for health and safety violations instead of doing an administrative fine. So they have greater powers for search and seizure. They have greater powers for accessing the charge approval process through Crown Counsel. And the court actually has specific powers in remedies that it can impose on employers if they're convicted of health and safety violations. And one of those is that the court can compel employers to publish facts about the offenses, either in a newspaper or in a company-wide newsletter. So there's this kind of idea of shaming, and is something that obviously an employer wouldn't want if they are found to have committed a health and safety violation. The court can have them, send out a newsletter detailing all of that, and that can go as well to the public in a newspaper. So those are things that just reinforce the need to be cognizant of health and safety obligations, and to certainly, seek advice if you are faced with an investigation, because the penalties and the consequences can be serious, and they can now potentially be criminal. Another important part of the amendments is what's called Schedule 1 of the Workers' Compensation Act. So Schedule 1 has a list of conditions and diseases that if the worker proves that they have the disease, there is an automatic presumption that the disease was work-related and therefore compensable under the Workers' Compensation Act. And there was a big push by the government to have COVID-19 added to Schedule 1 of the Workers' Compensation Act to simplify and make it easier for people who contract the virus at work to have that claim accepted. So again, there was a big protest on this because the government skipped the mandatory review process that usually occurs and usually goes to scientific studies and all this kind of stuff to determine the connection between the workplace and the disease. That wasn't done in this case. It was fast tracked through to the Schedule 1, and there's a concern that we're taking something that's a public health crisis and something that's properly dealt with through public health resources and posing that on the workers' compensation system and having employers pay for those costs through the accident fund. So the one kind of saving grace to this is there is a condition that says the Schedule 1 presumption only applies if you are in an occupation that has significantly more exposure to the disease than the general public. So this probably will be limited to the healthcare sector and other industries where you actually do have a greater exposure. It's not just going to be an automatic presumption for every single employee. Some interesting statistics. As of the end of October, there's been just under 1,500 WorkSafeBC claims for workers with COVID-19. And of those, 445 have been allowed, 720 have been disallowed, and 186 are pending. So at this point, we see that there's still less than 50% of claims being allowed. But I expect that with this new presumption, that ratio is probably going to change, where we're going to be seeing more accepted than not, particularly in the healthcare industry. So that's a picture of where we're at now. Where are we going? I previously mentioned the Patterson report, and this is the fifth and final report to consider. This was a full workers' compensation system review done by Janet Patterson, who's a former labor lawyer with strong connections to the BC Federation of Labor. And she had looked into changing the workers' compensation system back in 2009. And when she started her review in 2019 at the request of Minister Baines, it quickly became clear that she was going to go beyond the terms of reference that had been provided to her and look at doing a full overhaul of the entire workers' compensation system based on the ideas that she presented to the BC Federation of Labor in 2009. So as a result of this, there was a strong reaction from the employer community, and the 46 employer community partners actually formally withdrew from the review and refused to participate, as they said on the record that they lost confidence that the review would be done in an independent manner. And so the review proceeded without a lot of input from the employer community. And the report is a mega report, and it's no less than 517 pages. So I'll admit I've not reviewed the whole thing myself, but I intend to. And it's basically an expansion of the worker-centered approach that was mandated in the Peachy report. So there's 102 recommendations, and at this stage, it's not clear, which ones will be implemented and when. But I did want to highlight a few, so you can get a sense of what's maybe coming. Some of them are very practical and reasonable. For example, allowing email communications between the board and the participants. Right now, everything happens by letter. It's a slow and cumbersome process. Secondly, there's a proposal to have one case manager assigned to a worker's claim from start to finish. So again, that's something that I see regularly is there's 4, 5, 6 case managers throughout the claim, and every time a new case manager comes on, they don't know anything about it, so you get inconsistent decisions and all that. So some of those things I think are going to be good, but there are many more significant substantive changes, most of which will probably result in more claims, more expensive claims, and ultimately greater costs for employers. So I'm not going to go through them in detail, but a few highlights. There's a proposal to change the appeal period to the Workers' Compensation Tribunal. It's currently, you have 30 days to do it. They want to change it to 90, which is consistent with the review period for the first level of appeal at the review division. Again, that's going to bring in a ton more claims because a lot of people don't appeal within the 30 days and then their appeals are barred. Currently, vocational rehabilitation appeals end at the review division level. So the proposal is to allow one further level of appeal to WCAT, Workers' Compensation Appeal Tribunal. Again, it's going to be more appeals. There's a proposal to add compound interest to any retroactive payments that are made to workers. So if a worker wins an appeal and is awarded 6 months back pay, they're looking at adding compound interest to that payment. Currently, there is none. There's proposals to establish other advocacy groups, which would be in addition to the Workers' Advisor's Office and the Employers' Advisor's Office, which are currently free resources for workers and employers. There's a suggestion to establish some additional advocacy groups for other types of workers. There is a proposal to establish protection and a remedy for a worker who faces retaliation for filing a compensation claim. So currently, I'm going to talk a little bit about prohibited actions. So currently, employers cannot retaliate against a worker if they raise a health and safety issue, but there isn't technically any prohibition against, or there isn't a way to complain against an employer if a worker thinks they've retaliated against them simply for the fact that they've made a WorkSafeBC claim. So Patterson would have the system change to add this additional type of complaint, which again is going to create more litigation, more costs. There's a proposal to give WorkSafeBC the jurisdiction to rule on human rights matters such as discrimination and the duty to accommodate. And Mike will go into that in some detail, but right now we have the Human Rights Tribunal who has the exclusive jurisdiction along with arbitrators in the labor context to deal with those sorts of things. So adding another layer onto the WorkSafe system is going to cause confusion. It's going to cause inconsistent rulings, and probably is just not going to be a good thing. Another big one that's proposed is to expand the definition of mental disorder to include not only accepted psychological conditions that are assessed by a psychiatrist or psychologist, but any psychological injury. So, right now, these sorts of claims are limited to things that a psychologist or psychiatrist would diagnose, things like depression, panic disorder, anxiety, PTSD, that kind of thing. Expanding the definition to, these vague concepts of stress or emotional upset, again, is going to open the floodgates probably for many, many more mental stress claims, which I'll talk about in a little bit. I'm going to go to the topic of bullying and harassment. And I've just been told I've only got 5 minutes, so I'm going to fly through this. And Mike will talk a little bit about the concept of harassment in the human rights context. But I wanted to touch on it in the WorkSafeBC context as well. There's 3 ways that WorkSafe can be involved in bullying and harassment. And I've put a definition up there, which I think is a good definition to look at and include in your policy manuals. It's any inappropriate contact or conduct or comment by a person towards a worker that the person knew or reasonably ought to have known would cause that worker to be humiliated or intimidated, but excludes any reasonable action taken by an employer or supervisor relating to the management and direction of workers or the place of employment. So that's kind of the basis of how WorkSafe looks at bullying and harassment. And there's 3 ways, as I said, that they can become involved in bullying and harassment. First, as a regulator of the employer's policies and procedures. The employer has a health and safety obligation to have a policy on bullying and harassment and to follow that policy. So the policy must include, investigations procedure, the roles and responsibilities of the parties, and how records are going to be kept. And so if you don't have that, you need to make a policy. It's something that should be in your employee handbook or manual. And if you don't have it, WorkSafe does an investigation arising from a complaint. They could note that, send it to their prevention officers, and you could be, penalized. So that's the first way that they can do it. The second way is something I mentioned before, these mental stress claims or mental disorder claims. So a worker that suffers mental stress injury in the course of employment can make a claim for WorkSafeBC benefits under Section 135 of the Act. I've set out the section of the Act there for you to look at, and basically it requires a number of different things, but at its core, there needs to be either a traumatic event or a significant work-related stressor that's caused the mental disorder. The mental disorder itself has to be, as I mentioned, specifically diagnosed by a psychologist or a psychiatrist. The mental disorder cannot be caused by a decision of the employer that relates to the worker's employment. So this is known as the labor relations exception. And it's a very important exception that, again, the Patterson report wants to narrow. So some statistics, mental disorder claims are on the rise. You can see in 2017, there was just under 4,000. 2019, there was 5,500. So they're increasing, at the rate of approximately 1,000 claims a year. You can also see on the left side of the graphic that more and more claims are being allowed. So in 2019, 63% of the mental disorder claims were allowed. And I expect and anticipate that 2020, the numbers are going to be even higher. And I think that's going to continue to increase given the toll that COVID-19 is playing on mental health, and also the continued prevalence of the Me Too era. So I'll talk a bit about bullying and harassment investigations. Where a worker makes a mental stress claim, WorkSafeBC is mandated to go into the workplace and do a harassment investigation. And this can cause some serious issues for employers because this investigation will occur regardless of whether you as the employer are conducting your own investigation. And WorkSafeBC is going to go in there, interview witnesses, and make findings about what happened in the workplace, which may not necessarily be the same conclusions that you come to or your investigator comes to if you've retained a third party. So, if you are facing an investigation that WorkSafe has done and you disagree with the results, you do have a right to seek a review of that. And sometimes the implications of the investigation can be far-reaching if you've decided to discipline or not to discipline the person that's been accused of the bullying and harassment. I'll go now quickly to the third aspect in which we see bullying and harassment in the WorkSafe. That's prohibited action complaints. So these were formerly known as discriminatory action complaints. And basically the essence of them is to punish employers for retaliating against workers who raise legitimate health and safety concerns. So if somebody raises a complaint and that complaint relates in any way to occupational health and safety, if the employer takes any sort of negative action against that person because of the fact they raised a complaint, that is called a prohibited action. So a prohibited action is defined broadly. It can be any sort of a negative or adverse effect relating to that person's employment. It could include, discipline, suspension, demotion, lower wages, termination. It relates to bullying and harassment because bullying and harassment is considered an occupational health and safety issue. So nearly 50% of prohibited action complaints cite bullying and harassment as the safety concern that led to the alleged prohibited action. And we can see from the graphic there that, again, bullying and harassment related prohibited action complaints are on the rise. There were 456 complaints in 2019. That's up from 377 in 2015. And so it's important to recognize that when you do have a bullying and harassment complaint, to tread very carefully and consider any liability you might have under these provisions if you down the road decide that you need to make changes to the person that has complaints employment. If that decision is in any way tainted by the fact that that person has raised a health and safety issue, you may be faced with a discriminatory or prohibited action complaint. And the reason they're so scary is the remedy. It's a make whole remedy that WorkSafe provides somebody who can establish liability for a prohibited action complaint. So if you have terminated somebody and that person can prove that it was tainted by the health and safety complaint, you can be liable either to reinstate them, bring them back to your workforce when clearly you didn't want them there, or have to pay them all of the wage loss that they've suffered since the termination. So if that person hasn't worked, and these complaints can take up to a year or 2 years to get adjudicated, if for whatever reason that person hasn't worked, you could be on the hook for a year or two of wages. So again, seek advice if you're faced with one of these complaints. It's important to get advice early in the process because the investigation is done within a couple of days of the complaint. And if you're stuck with having to do an appeal, it's more challenging for us to help you. So those are essentially my comments on bullying and harassment. I was going to do a COVID-19 update. I will skip that. We've done previous seminars and blogs on the COVID-19 safety plans and the refusal to work process. We've linked the blogs to the slides, so you can go there, talk to me after. I'll leave with a quick stat. As of October 29th, WorkSafe had issued 627 COVID-19 work-related violation orders, and that was based on 17,000 inspections. And so for the most part, employers are doing pretty good at putting together their plans, making sure that things are safe. And my impression and experience in hearing from clients has been that the prevention officers are focusing on education and guidance as opposed to penalizing people that might be technically in breach. Okay, that's it for me.
Okay, Chris, that's excellent. As you can see from the detail of this type of presentation, what we're looking at with these presentations is setting up our fall and winter webinar series, and clearly we may be having a more detailed, a more granular webinar on WorkSafe issues. So that's something to keep an eye on, and we invite your questions following Chris's thing. I'm looking forward to somebody defining what an employer's obligation is to have a psychologically safe workplace. So you can see lawyers love the interesting questions, but that's going to come up at some point. I'm also going to leave you with this from Chris's presentation, and that is I am a big believer in businesses, small, large, medium size, joining the employers forum on WorkSafe. It's an extraordinary group. It's run by Doug Alley, formerly of the Business Council, and he does a great job of keeping employers not only informed, but taking action, acting as a group. With the NDP being in for 4 years, we need a strong voice, as we have back in 1992, from a business community in all of these areas. So I think from an educational point of view, as well as being able to lobby and deal with the government on these changes that they're bringing in, highly recommend you do that. If you want information on the employers forum, just email us and we'll send you that material and connect you with Doug. And I think you'll find it's a very useful operation. So we're now going to move to succession planning, employee takeover and buyout, which is becoming more and more as corporations are going through reorganizations as a result of COVID. And Darlene will have some interesting aspects, options that you may be looking at, as well as your employees be looking at it. And Darlene, we've got you on the clock till 11:10, 11:15, something like that. So Darlene, go ahead.
Thank you, guys. Thanks for letting me jump in on your labor and employment series. I'm going to take a bit of a different turn now and talk about corporate things. So I think in terms of the attendees here today, some are owners, some are HR people, All of you probably have a vested interest in your business and your jobs, and making sure that there's some sort of future for all of them. So one of the options that a business owner has, of course, is having employees slowly buy them out. That sounds simple. You own a bunch of shares in a company, you've got some key employees who are willing to invest the money to slowly buy out your interest. Easy. But there's tax implications. There's tax implications for you as the outgoing shareholder, and there's tax implications for the incoming shareholder. So I'm going to talk a little bit about company structures and some of the concepts that when I'm dealing with a business owner and we're starting to plan for the future exit of the business, whatever that looks like, we have to sort of wrap our heads around a few basic concepts, and it's going to apply to almost any one of your companies. Whether or not the parties coming in are employees, they're arm's length people, or they're family members, that makes a big difference on the tax treatment and what options we might have. The type of company you have, most companies will have at least one class of shares. If your company was incorporated by a lawyer of a mid-size or larger firm, you're going to have multiple classes of shares. Often we see companies that somebody's created on their own. They've gone online and they've just created this company and they gave themselves 100 shares. They didn't even call them anything, they just called them shares. We can work with that, but it requires usually changing the structure of the company to get it to what we want to do. So talking generally about shares and companies, all shares or all companies have three attributes built into their shares: the right to vote, the right to receive dividends, and the right to receive the value on a wind up. We can split the shares so that some shares only have some of those attributes, or multiple types of shares have all of those attributes. And that's where we can start to play with things. And when we're bringing in, for example, an employee buyout, that's when we need to have different types of shares. Sometimes a outgoing shareholder wants to slowly hand over the reins to the employees, but really wants to keep control, knowing that the employees can't afford to buy them outright at the first instance. So it's going to be a slow buyout over time. So we might actually give all the controlling shares or the majority of the controlling shares to the outgoing shareholder, but the right to profits in the future will be split between them. And the only way we can do that is if we have different types of shares, different classes of shares. Part of what we're going to look at when we are talking to outgoing business owners is, do they want their money right away? Do they still want to be involved? Do they have a retirement plan? Because that's part of it. And in fact, when I deal with companies, my 20 and 30-year-old business owners, and they're incorporated for the first time, I ask them right at the front end, what's your goal for retirement? Because I might as well set up your company now with some attributes that's going to make it easier for you in the future. When most people created, assuming that all the listeners today incorporated their own companies or started them up from the ground, the value of the shares is minimal, $1, $10. It's very small, maybe 10 cents. The value of your business today might be worth $1 million. If you sell all those shares, that's a $999,000 plus gain. That's a taxable gain to you. If you roll them over to a spouse, that's exempt, but then the spouse, when that person sells or gets rid of their shares, they'll be taxed. Certain types of businesses will make the share sale, you'll have an exempt amount. Right now, the exempt amount is $883,000. If your business qualifies, then you can dispose of that amount of share value and pay no taxes on it. So from an outgoing shareholder perspective, that's a beautiful thing. Selling your shares to an employee will get you that exempt amount most of the time if it's done properly, but it does have to be papered. Tied to the departure of the company and your future income is also what your retained earnings. So for those of you who look at your financial statements, you've got a retained earnings column in there. I see a lot of businesses that leave retained earnings in their company for a variety of reasons. It's mostly tax driven and how they've taken their money out of the company over the years that they've had it. But it's not unusual for me to one day see a company sitting on $800,000 or $900,000 of retained earnings. So that means the value of the company is at least that amount on paper. So for tax purposes and how Canada Revenue Agency looks at the distribution or the sale or the transfer of the shares in the business, that's a number they're going to be looking at to put value on. And sometimes that doesn't quite reflect the reality, and it doesn't get people where they want to be for tax purposes. Tied to succession planning is estate planning. And I often look at both of these at the same time to see what the long-term plan is. And I'm just going to divert for a second and talk about what happens when somebody dies and they own shares in a company. It's a deemed disposition. It's as if the shareholder sold all of their shares in the business. So if there's these retained earnings sitting on the minute books, that means the shares have the value of at least those retained earnings. And now that it's as if the deceased shareholder sold their shares. That is probably not going to qualify for that that exempt amount. So that will be income to the estate. So if you had $800,000 of retained earnings, it's as if the deceased earned $800,000 in the year that they died, which would put them in the highest tax bracket. So you're looking at a $370,000 or $80,000 tax bill that's going to be paid. So the retained earnings is a very important thing that we look at when we're doing our succession planning and estate planning. So when somebody's leaving and when employees are coming in, they've got to look at that number. They've got to look at the financial statements very carefully. The other thing to consider with employees coming in, so if you created your company and the shares were $1 when you started it, and now you think your business is worth $500,000, and you say to your employees you can buy half for $250. When they buy your shares, if that's what they do, they're buying the shares at $1, and they're paying you $250,000. So they will not have the cost base that reflects what they actually paid for them. We can give that to them, and there's a way to do that. But if you just tell them without doing the planning properly, yes, why don't you buy some of my shares? As the outgoing person, you're going to get a great tax position. It's a third party. You're selling shares. You'll claim your exempt amount up to 883, so you won't pay any taxes on it. But now the buyer, if they paid $250,000 for taxes, they hold the company for 10 years and they sell it for $500,000. They will pay taxes on the full 500. They won't get the advantage of the bump up to the 250 unless we do some things with them as well. When I'm working with outgoing shareholders and succession planning, part of what we look at, and even though it's not our job, but we look at what's the tax implication to the incoming party. It's not fair to saddle them with a big tax burden that they don't even know what they're getting into, especially if they're employees. They're trusting that you're not going to sell them down the river. They're trusting that you're actually going to give them something of value, and you're not going to stick them with a tax burden that you have no idea about. So I could take the position and be really aggressive and say, yeah, no, that's their problem. They have to deal with it. But the reality is most of my employers want to do something nice for their employees, and they want the transition to be smooth, and they want the company to succeed. So when you're looking at succession planning, an employee buyout it makes sense. It's easy. They know the business. You can still control it. You can slowly distribute your shares. You can give them stock options, which is good for them. That gets over some of that hurdle that I talked about in terms of the not being able to capitalize on the cost base that they bought it at. So stock options is an option. Your company structure, whether it has a single type of shares, common shares if you created it on your own, or we or some other firm created it, you're going to have 10 or 15 classes of shares. We can work with all those different structures to slowly pay out the employees. It gets pretty complicated. It involves a conversation with your accountant. It may involve a tax planning lawyer or a tax-driven accountant to kind of look at the tax implications on your sale of your shares as well as what they're getting when they buy in. Combine that with what your ultimate goal is as a person leaving the business. Do you want to have a stream of income? Do you want to have, because you could have a slow buyout where they just pay you over time. We do a shareholders agreement. We might put shares into trust or in an escrow. Slowly you get paid and slowly they get the shares. That's one option. Another option we could do is they buy the shares, you finance it, or the company finances it. So they can, they're slowly going to pay you your money, but maybe instead of you taking all the money in one big chunk and paying taxes on it immediately, if some of it's taxable or if you don't qualify for that exempt amount, if we get in early enough, we can reorganize your company and we slip in another company underneath it, and then it's that company that sells the shares to the incoming employees. And that company can then sit on the cash. A company, as you know, each year it only pays income on it. It only pays taxes on the income that's earned. The tax to you as an individual, as a shareholder, it's not until you put the money in your pocket that you are then taxed on top of whatever the company pays. So if you had a holding company that sold its shares, and maybe there's $1 million in there, if you put that all in your pocket today as a shareholder, well, you're paying taxes on a big chunk of that. It's a big tax bill. But if you leave the $1 million in your holding company and you only take out the 80 or 90,000 that you need this calendar year, well, then you're only paying taxes on that 80 or 90. So you're going to keep yourself in a lower tax bracket, and you're going to be able to provide yourself some dividends over time. It's obviously way more complicated than this, and it is more technical. And how and when you pull the money out of your companies, whether it's a holding company or directly from the shareholders, I look to the tax lawyers to make sure that we're not inadvertently triggering additional taxes. When a person dies, if you happen to unfortunately die and you still own the company, not only will there be a tax bill for you, but if there's no cash available, then your estate is saddled with a big tax burden. So going back to that retained earnings concept, your share value is $1 million because of these retained earnings, and you die. Now you've just earned income of $1 million. Somebody has to come up with, $470 or whatever $1,000 of taxes to pay to the estate. If the company doesn't have the money, you've got to think hard about where that money is going to come from and what you're leaving behind with people. So it's all tied together for me, whether you're just looking at transitioning out of your business and selling to your employees, or whether you're planning for your estate planning and what happens with your shares and your family and or your employees. I can't look at one without the other. And looking at your share structure is one of the first things that we look at. Important to you as the outgoing person is, do I want my money and do I want to walk away right away? Am I willing to finance some of this? Am I willing to get paid over time, knowing that the buyer doesn't have the cash, but they will slowly? So basically the company pays you out. That's quite tricky, involves a more complicated structure for us, but we can do it, and we do that over time. If your employees can't afford to buy in, one option is to freeze the company. So you take the whole value, let's use $1 million again. We say your company's worth $1 million. We freeze it. We issue $1 million of preferred shares to you, the outgoing person. And the employees then get some shares. They get them for $1. Maybe you give them all $1. And we just structure it in a way that the company will redeem the shares over time. The company will pay out on those shares $100,000 a year for 10 years. And as the shareholder going out, you're simply going to get your $100,000 as a dividend. It's income for you in your pocket. And you're just trusting that the company will continue to be run to be able to pay that. The difficulty with a long payout is, will the company still succeed without you? If you set up your company properly and it's able to run without you being there, then you're probably okay. So for all of my younger business owners, I encourage them to not be the only face of the company. The company has to exist on its own. You have to build it so that it will be able to run independently of that specific shareholder. It's a tough concept because most shareholders owner builders are really proud and they want to say they're the owner, but I'm encouraging them to say they're a director. they're managing director of the business, and they try to create something that will stand on its own so it has more value. If the income or if the value of the company is strictly on one person being able to go out and get the sales, then there's a good chance that what you've got to actually sell to employees is not worth that much. And it becomes a tricky balance of trying to be able to convince the employees they should pay for it. And if it's over time, of course, you might not get the money. If you do nothing, I mean, we talk about different ways to get out of the company or to transition out of your business. You could do nothing and walk away at the end of your business. You might be leaving a lot on the table. You can sell to your employees, and we do that, and it's good. The employees have a vested interest. They're motivated. They want to make more money. They know that if there's profits at the end, they're going to get more. You can sell to your family, but that's a little bit trickier. Their family is not arm's length, but sometimes there might be a person in the family that's prepared to carry on the business. That involves a bigger conversation if there are other children, because usually it's a part of a bigger estate. And of course, you can always transfer to your spouse. That is usually a tax-free transfer, and we use that. Prior to getting out of the company, we would look at maximizing that capital gains exempt amount as well. So the 833 or 883,000 currently is what it is. If we can find a way for your spouse to also get some of that exempt amount, if the business is worth $2 million, if we can get 1.6 of it exempt, that's fantastic for the seller. So these are some of the things that we would think about as well. I'm not going to go into the really intricate details of the types of the steps that we would do to do these transactions, but the primary part of it is that we work with the share holdings that you have. We almost always have to reorganize your share company and restructure it to allow for employees to come in a meaningful way. That's not bad for them, nor is it bad for you. We've got a question on the in the question and answer there about asset sale and share sale. From a selling perspective, you want a share sale because you can get that 888,000 capital gains exemption most of the time. So you check with your accountant and say, am I in the category? Do I qualify? If you're an operating business, you probably do. That's ideal for an outgoing seller. An asset sale has worse tax implications for the seller, but has better tax implications for the buyer. So it's often a push-pull between the vendor and the purchaser, whether they want an asset or a share sale. There's a way for the buyer to still have a good tax plan if as an asset, or sorry, as a share purchaser, but it does require educating them, and they have to have a good lawyer on their end who knows how to paper what needs to be done and understands what we're doing. So it can get complicated. In terms of a buyer, we want to buy assets, so we don't buy the liabilities of the company, we just buy the stuff. We take over the people, we rehire all the employees, we take over the assets, we buy your contracts, we buy your goodwill, and it's just an asset purchase. As a buyer, if I paid $1 million for the business, my cost for the business was $1 million, and that's my cost base. So if I sell it for 2, I'm only paying taxes on the difference between the 1 and the 2. For the shares, if I buy the shares in the business, I'm buying the liability of the company. I'm buying all the potential lawsuits. I'm buying any of their tax problems. I'm buying their tax filings that they did for the last 3, 4, 5, 6 years. That's now going to be my burden. Usually, if I bought the shares, I've also bought them at $1 as far as the paper is concerned. So if I paid $1 million for them, CRA is going to look at that and say, no, they're worth $1. So if you're selling your shares down the road for 2, you don't get that cost base of the first $1 million. Again, we can get around this almost always. We can work with both sides of it, but most sellers want to sell assets to third parties. Most buyers want to buy the assets from a business, and most sellers want to sell the shares. If there's employees that are closely within the company and they know what the company does and they understand the company well, it will be easier to tell them that a share purchase is a good idea. If you're selling to a third party, they usually don't want any of your ghosts They just want to buy the assets. That's the very, very overview version of the two types of transactions. For employees, stock options, it's a great way to slowly divest yourself of your interest in the company. Slowly have them buy in, even if they just buy 5% today, and then you can offer them 5% more down the road. If you do a share sale to employees as part of your exit strategy, you have to have a really good shareholder agreement. The risk is you take on this employee because you think he's or she is really good. They become a minority shareholder with 5% of the company, and they just don't pull their weight. Or now you have to lay them off because they're not even doing their job. When an employee is also a shareholder and or a director, they're wearing multiple hats. And Mike Weiler and Chris can talk to you at length about how complicated that type of litigation can get. Because that person, if they're unhappy, has multiple avenues to pursue against you or the company if there's a dispute. That's the type of litigation I warn people of when they walk in the door to get the checkbook out, because it's going to be ugly. So if you do go with the sort of longer, adding employees a little bit, there is risk. We paper that as best we can, but there's, aside from straight out selling the whole thing to them, there's not much way around some of it. As good as we make our documents, I'm a solicitor, I make the documents, I build them, I think they're perfect and beautiful, and Chris gets his hands on them and he shreds them, and they go and they fight with, $200,000 in legal fees. So I go back to the drawing board and I redo my documents. It's frustrating, but the reality is we were always fine tuning our documents to allow for the types of claims that come forward. That's all I'm going to say about employees. There's lots of options. If anybody's out there wanting to talk about it, I could spend an entire day doing a presentation on succession planning and things to look out for. But I think we're going to move on to Mike now. But his screen looks frozen. Is that?
Medium-sized businesses, and many of them are family-owned businesses. And so what Darlene's talking about are items that often are not thought about, and that is the successorship. As the future gets an awful lot closer for the owners of a business, family business, especially if you're fortunate enough to have one or more of your children working in your business, having it set up properly is so extraordinary, not only to avoid taxes, which is a critical item, but also to avoid a family feud down the road. So we strongly recommend that you think about these things. Do your planning for successorship within your company, because it's important to make the decisions now, not down the road. Okay, everybody fasten your seatbelts. We're going to try to get through a fairly detailed commentary on human rights. So that's how we're going to start. Now, I've given an introduction, some quotes that I often have to remind clients and myself how businesses have to consider human rights and wrongful dismissal actions from the perspective of the courts. And the courts talk about human rights. I've given you the Robichaud quote there, Supreme Court of Canada. They talk about human rights as almost being constitutional rights. So that shows the significance of how they approach it. The other thing is they talk about work being the most well-being. And so you'll see that in all of these decisions that deal with human rights tribunal. That is the perspective courts take. That's the perspective tribunals take. So it's useful to have that in mind as we proceed. So this is a very complicated area of the law, as many of you that have unfortunately been involved in human rights complaints will know. Today I'm going to just focus on the BC Code. I won't be talking about the Canadian Human Rights Act. Many of you are part of that. Many of the principles would apply, but you'd have to get some specific advice with respect to that act. I'm going to limit my comments to Section 13, which deals with employment, discrimination with respect to employment. But note that human rights does arise in a number of areas outside the employment relationship. Section 8, for example, deals with the provision of services. We have various cases. One of them is the Shoppers Drug Mart. The person came in wearing a hoodie and was not pestered by the owner, the manager, and then subsequently filed a human rights complaint that had to be dealt with in that context. We've got going back to many, many years ago, the Vancouver Sun was sued under the Human Rights Act back then for not putting in ads dealing with gay businesses. And the complainants were successful. So the other interesting one that I've become involved in is the strata councils. Being president of our strata council, there are numerous cases dealing with strata councils. So if you're involved with one, you may find that you get a human rights complaint. There was just a recent case in Nanaimo where a woman was awarded $35,000 for hurt feelings because the strata council had not taken sufficient steps to accommodate her disability. We also have an interesting case dealing with the car dealer who was faced with somebody who had a hearing. Sorry, no, I've not been frozen in real life, so just assume that I'm still moving. The car dealer case is interesting. A person had a hearing disability and claimed after that he was not accommodated enough by the car dealer. He thought it was an electric car, and in fact it was a gas-powered car. So that case got punted, but it just shows you the breadth of complaints that can arise under the Human Rights Code. Note that proof of intention that you intended to violate the Human Rights Code is not part of human rights complaints. They look at the effect of your actions, not your intention. Okay, next slide. So the theme of our discussion today is human rights within a COVID world. And I see a number of areas where we're going to see not necessarily an explosion, but an advancement of human rights complaints that weren't there before. I think there's going to be a lot more mental stress claims, including PTSD claims by healthcare workers. That's pretty clear. I'll talk a bit about family leave complaints. That's one of the few areas of good news for employers. But I think those complaints are going to arise. We're going to see increased damage awards because employees aren't going to be able to mitigate their damages by finding another claim. They're finding another job, I should say. You're going to see substantial delays in the processing of complaints, so that creates a problem. If I'm going to a hearing 3 years down the road from when the complaint was filed, which may have evidence prior to that, it's going to create problems of proof. The big thing is my client may get hit with a damage claim for 3 years' wages plus others. So it's good to move on these quickly. Reinstatement will become, I think, in a COVID world, because of the lack of jobs, the attraction of the economy. I think you're going to see employees looking more and more for reinstatement. Addiction cases, I think they're all, unfortunately, people are in a bubble. We're going into a dark winter. You may find we're hearing more family violence situations. We're also seeing more addictions, and that's going to be a problem. There was a case called Gooding that I won't bore you with all the details, but somebody who was a manager, but covered by a union collective agreement, was found stealing significant amounts of alcohol. His defense was, I'm an alcoholic, and therefore that explains one of the reasons why I had to steal. There were 10 years later, the BC Court of Appeal finally dismissed the claim ultimately, but there were 4 Labor Relations Board cases dealing with it, 3 arbitration cases before Stan Lanyon before he decided to dismiss it, and the matter went all the way up to the Supreme Court of Canada. So these can be very detailed one if you pick the wrong case. Arbitrators under collective agreements who have much broader authority than really people under the Human Rights Tribunal. I think they're going to be looking more for innovative remedies for employees, something to watch out for if you're a union. But at the same time, the duty to accommodate, I think, may be scaled back a bit, because one of the considerations now has to be that we are in a different world and that COVID is causing severe economic distress for many, many employers. And the costs of accommodation, which may have been reasonable a year ago, aren't going to be reasonable going forward. Otherwise, the whole enterprise is going to be in jeopardy. So those things I think may come into play. So there's also related legislation that may be something you have to consider. There's many areas where they overlap. For example, if you have maternity leave issues, there are two very distinct ways employees may pursue those complaints. One is under the Employment Standards Act, which I think is the more usual one, where they apply for maternity leave and the employer makes some changes or terminates, but also they can bring a human rights complaint. The advantage of a human rights complaint from a complainant's point of view is they can get damages for injury, dignity, etc. So you may even find both complaints. Many of you would know from our blog that the provincial government amended the Employment Standards Act to provide for COVID leave. And that leave is in section 52.12. And it basically deals with people that are not able to go to work, who request a leave of absence. They get an unpaid leave for the period of time for which the disability of COVID or the constraint of COVID applies. So if they have to take care of somebody who is afflicted with COVID, they can apply for that type of leave. The other thing is the employee, maybe the employer may say, look, we're concerned about COVID, we want you to stay home. They can apply for a leave under there. The critical point being that these are huge advantages for employees, similar to human rights, in the sense that you must reinstate them after the COVID leave is over. WCB harassment and bullying complaints, we've talked about that with Chris, they often spill over into human rights complaints. And there's also jurisdictional issues that I've noted there between workers' compensation claims and human rights complaints. The Supreme Court of Canada has tried to bring some common sense to that and punted a human rights complaint when the WCAT had basically dealt with it and made findings. And they said, look, you know, we're going to avoid unnecessary prolongation, duplication of proceedings that have already been decided with another authority, although there is, as I've noted there, a case that creates a problem. So here's another issue that you may or may not find spills over into your business, but the introduction of UNDRIP, the United Nations Declaration of the Rights of Indigenous People, now is part of our law. And so that may impact, we don't know, but we may impact on businesses that are dealing with Indigenous populations. So the NDP have been busy little beavers since 2018. We know that there have been huge changes to the Employment Standards Act. We know that there are huge changes to the Labor Relations Code. More of those are coming. My fear is that the NDP now in without the grip of the Greens, we're going to get rid of the secret ballot vote in union certifications. That's a biggie. But they also made fairly minor changes. This is done by David Eby, the Attorney General, is responsible for human rights. And in Bill 50, he brought in, he created the Office of the Commissioner, which has powers to promote, protect human rights, which, you know, it sounds like a great idea, and I'm sure there'll be some great innovative ideas out of it, but not likely going to be great for employers. The other one that I wanted to draw your attention to is the time limit for bringing a complaint has been extended from 6 months to 1 year. And so you've got a problem of, you know, stale evidence and somebody well down the path filing a complaint. And by the time you get to look at it and prepare yourself, it could be many years. The other thing is continuing contraventions. And I won't go through what constitutes a continuing complaint, but it can easily draw in evidence from previous years. I had one where the complainant had evidence going back. He was discriminated against for like 5 years, notwithstanding that he had a union and notwithstanding that he never filed a grievance and notwithstanding that everybody said that never happened. He filed it, so the employer had to respond to it. So again, it's something you have to deal with. But those amendments will impact on you. Next. Section 13 is what I'm dealing with. That's the one that deals with discrimination in respect of employment. the headings of, as I'm sure all of you know, race, color, ancestry, place of origin, political belief, religion, marital status, family status, physical or mental disability, sex, sexual orientation, gender identity or expression, or age, or someone who's been convicted of a criminal or summary conviction offense that's unrelated to employment. So that's the bucket of areas of discrimination that could found a human rights complaint. One of the things to bear in mind is you'll often have people say, well, I was bullied and harassed, and therefore people are thinking that they have a whole bunch of rights under the Human Rights Code. Bullying and harassment can be adverse effects, but they're only relevant for human rights codes if it fits into one of the prescribed areas of discrimination. So be careful when somebody just goes around bullying and harassment and all these rights. They may not have those rights. The other thing is, bear in mind that these apply to hiring. Now, if you think that could be, what's the big deal? Well, an Ontario company, Imperial Oil in Ontario, for a person where they revoked the offer of employment because the employee had lied about his ability to be a permanent resident, the Human Rights Tribunal said, well, even though he lied, he only lied because you asked him about permanent residency, and we think that's a proper question. And here are the damages: $101,000 in lost wages, $15,000 injury to dignity. So those are big costs that can come out. And where you have to be careful is whatever questions you ask, whatever documentation you have. If you're not going to hire somebody, what you do to follow up. That's why thinking about these things is useful for acting. As many of you know, the taint theory applies to human rights. That is to say, if I have 10 reasons why I'm doing something, but one of them is based on a prohibited ground, my decision is tainted and I have violated the Human Rights Code. Okay? And the other thing that's interesting that's going to get more analysis, I think, is whether or not, what's a disability? Is just simply having stress? I mean, we all have stress. I had stress this morning when the electricity went out 10 minutes before I'm supposed to be on this webinar. So there's, lots of things that create a world of stress, and COVID is certainly one of them. But it has to get to a much higher level, in my view, before it's going to be considered a disability. But COVID may well be considered a disability. I quoted a case there that I just read yesterday, where somebody was terminating a tenancy because they were concerned that person was not following the rules on COVID, had a potential of being infected by COVID, et cetera. And it was the business or the landlord in that case tried to have the application dismissed, and the Human Rights Tribunal would not dismiss it. The issue of whether or not COVID per se is a disability, I think we decided yes, it is. But that's another interesting question that will feed you as the cases come out. Okay, people say, what's the duty to accommodate? Well, in the old days, there used to be two types of discrimination: direct discrimination, that is, I say, sorry, women do not apply for this firefighter position, and that's clearly discrimination. And under Section 13, I could only justify it if it's a bona fide occupational requirement. But then a case involving a dairy company where they needed people to work on the weekend said everybody's got to be here Friday night. And the employee said, well, my religion doesn't allow me to work Friday nights. And so what the Supreme Court of Canada came up with is, well, it's not direct. The rule itself is neutral, but its impact on you is creating discrimination, because it's discriminating on the basis, in that case, of religion. So they said that the rule is okay, but you have to accommodate the employee. So, work out somebody else, come in and fill in. Then the famous Marin case that, again, many of you, I'm sure, are aware of or heard the name. Marin dealt with forest fighters in BC. Back when the NDP was the employer, they were trying to figure out what type of aerobic tests, et cetera, would be appropriate to create a safe environment for forest fighters. And so they brought in a certain level of aerobic tests. And at the end of the day, it was found that women just simply didn't have the physiology to be able to meet that standard. But Ms. Marin had been a forest fire with no problem for many years. So in this case, it went to the Supreme Court of Canada. The Supreme Court of Canada decided, really at the agreement of the NDP government, that why don't we just merge these two concepts of direct and indirect adverse effect discrimination and just throw it all into this basic rule-based thing. So here's the test. The employer adopts the standard for the purpose rationally connected to the performance of the job. So in Marin, it made sense that they had to have rules on safety. The employer adopted the particular standard in honest and good faith that it was necessary to fulfillment of that. So, there's no question the government had experts say that these were good tests. So nobody could challenge it on that. Most of the challenge comes from the standard, is it reasonably necessary to accomplish the work purpose? And that's where the duty to accommodate comes from. In order to say the standard as it relates to those people that are affected, they must demonstrate it's impossible to accommodate individuals sharing the characteristics of the claimant without imposing undue hardship on the employer. Now, the Supreme Court of Canada says, look, we've got to have a common sense and practical approach to this. I don't think that's often what happens. That's what they say. So the factors that will support a finding of undue hardship are not entrenched and must be applied, as they say, with common sense and flexibility. And in my view, COVID has made this change. Businesses are in deep trouble, not just short-term, long-term, coming out of this in many areas, especially tourism, et cetera. So I think that a complaint today, an employer will have a better chance, especially a small and medium-sized enterprise, will have a far better chance to defend itself, that the cost will put the entire enterprise into jeopardy. And that's not something that generally has been accepted, but it can happen. Okay, I've given what I think is a really excellent quote on the duty to accommodate. And it comes out of the Quebec Hydro case. And I'll let you read it at your leisure. But what they said was, well, when we said in Marin, remember that it was impossible to accommodate without undue, we didn't really mean possible. It kind of meant like really hard. And what this case recognizes is that there's a balancing here. An employer has a right to expect people to show up for work. The employee has to be fit for work. And it's within that area that you have to accommodate. And so it goes on to say the test for undue hardship is not the total unfitness for work if the characteristics of an illness are such that the proper operation of the business is hampered excessively, or if the employee with such an illness remains unable to work for the foreseeable future, even though the employer has tried to accommodate, the employer will have satisfied the test. And that leads us to the end there. The duty to accommodate is therefore perfectly compatible with general labor rules, including the rule that employers must respect employees' fundamental rights and the rule that employees must do their work. So it's a balancing. The employer's duty ends when the employee is no longer able to fulfill the basic obligations associated with the employment relationship in the future. So again, it sounds very much in favor of employers being able to balance things. But in practice, as many of you will know, trying to figure this out, it's a difficult thing to figure out what's the important elements of duty to accommodate. The general principle, determination of employees seeking accommodation, but equally applicable is the applicant has an obligation to assist and facilitate the process and to accept reasonable accommodation. Well, for example, if you've got a union, they're also part of that. I had a case where we wanted to give the employee who was accommodated a job opening that came up, but we didn't want to post it. And we had a bit of a dogfight with the union. I was able to convince the union that that was compliant with its duty to accommodate. And so somebody who otherwise would have been looking to get that job didn't get it, the employee with the disability. So it's not the perfect accommodation that's necessary. It's what's reasonable. So the employee comes in and says, nah, I kind of like to work maybe Tuesdays, and you see I play golf Fridays, so I'd like to kind of have that. You don't have to do that. All you have to do is find something that's reasonable, and the employee has to be reasonable. I've given a case there on settlement and releases. Be very careful. I'll leave you with that. Frustration of contract. That comes out of the Quebec case that I just quoted. If you can show that the employee is unable to work and will be unable to perform his duties for the foreseeable future, then the contract simply comes to an end. It's not like it's intentionally terminated. It comes to an end by operation of law. So you avoid a wrongful dismissal claim, also avoid a human rights complaint. Very detailed aspects you need to look at, but this is a principle that you should look at, especially with somebody who's been away on sick leave for a long time. There's no general power to award costs like legal fees, but if somebody messes around at the hearing or doesn't follow the rules, the Human Rights Tribunal can actually award costs, which can be it's a pretty good stick for them to be able to use to keep especially self-represented claimants in line, that they may be liable for costs. Okay, I've given a list. The tribunal's powers include under Section 27 a number of ways in which a claim can be dismissed before it goes through an oral hearing, a lengthy hearing. And they're all very useful and should be looked at. The one that is the most used, and surprisingly, many employers are successful in having claims dismissed before hearing, is the third one, no reasonable prospect of success. It's a very powerful and surprising success in having the complaints dismissed, even though the tribunal can't make findings of fact. Now, I've given you a case that I'll talk about later, and I can come back and read the sections to you. That's probably the best summary I've seen of how the applications to dismiss apply, what onus is on the employee or the complainant, what you have to do to respond, how they deal with it. There are time limits and the rest of it. A very useful thing before you just say, well, I guess we better just get ready for a full lengthy hearing. Okay, and then there are other ones that are there. One of the things is the substance of the complaint already dealt with in another proceeding. Query whether or not you have investigations or outside investigators. That's going to be sufficient. Remedies, I've given the section of the Act. I'm going to focus on just a couple of things. The one that is not used a lot, but may well be used, is reinstatement. And especially if you're in a union setting and an arbitrator comes, arbitrators have the authority to apply the Human Rights Code. So if they apply it like the tribunal, they will most likely order reinstatement. That's what they do. Tribunal generally is not ordered reinstatement. Most often the employee gets another job. They don't want to come back. But I think that that's going to change with the lack of work. The other big one is the damages compensation for injury to dignity, feelings, and self-respect. I don't know what the difference is between the three of them or among the three of them, but it's a general heading. Those numbers can get big. The big advantage to a complainant, and indeed even an employer who's trying to settle something, is that it usually will come, any award would be tax-free. So kind of doubles the value to some of these complaints. So those are the general remedies. I won't go through all of them, but they can be pretty significant. Early settlement conferences. What happens is when a complaint's filed, it's sent to you, and you are, as the respondent, they do some original, some hands-on triage to see if the thing is proper. So, for example, if somebody's employed by a bank and filing a human rights complaint under the BC legislation, they'll tell the complainant you don't have a case because we don't have jurisdiction. But generally, you'll find out about it. And then you've got a choice. You're at the Yogi Berra fork in the road. You've got to decide what you're going to do. Either you have to put in your response, and then you're on a process of providing documents. Or you can say, let's just go have a little chinwag down at the tribunal to see if we can solve this. So you don't have to put in your response. You don't have to provide your documents. You can go down. I really think it's a useful tool. Many of these cases, the employee just needs to vent. And the mediators, in my experience, have been very good at helping me find a solution for everybody. And even though my clients may have to hold their nose a bit by giving a compensation, they can pay me or they can pay the complainant. The real advantage I see is that I get a general release. I just don't get a removal of the human rights. I want a general release. so they don't come back after us for damages for wrongful dismissal. And so that could be something that I think a lot of people overlook. And they say, why am I going down there? This guy doesn't deserve anything, yada, yada, yada. There is some value. I want to talk about delay. The Human Rights Tribunal is so overworked right now. They just have no capacity. And I know this because the chair of the Human Rights Tribunal has engaged a bunch of us as counsel for respondents to say, look, I know we're really messing up here. What can we do to solve it? So, for example, an application to dismiss should be decided within 90 days. Well, I filed an application back in July 2019. We just received the decision dismissing it. And that may have been in part because the chair is sort of running around and telling people to get these decisions out. So who knows how long it would have gone. So why is that delay a huge problem for you? Well, it can be. For example, let's assume I had lost that case, the application to dismiss, which you can do. Then we get it set down for an oral hearing. A whole bunch of procedural things go before. So we could be 2 or 3 years down the road before I'm in an oral hearing. And then you're looking at huge damage. So that delay can be a very, very difficult thing. My suggestion is, whether you go to early settlement conference or not, get your ducks in order right away. Get the witnesses, get all that stuff done, and you can do it. You can do most of it without having the lawyer come in and do it. But get the facts down and the evidence preserved so that if it is a 3-year hearing down the road, you've got your ducks in order. Next. I put an article in very timely yesterday or 2 days ago in the Sun. Mental health is a growing worry in the workplace. I don't know about you folks, but I'm kind of stressed looking at the winter, darkness, all the activities that I do in the winter are going to be limited. So that's just, my particular situation. But I think we all recognize this is a very difficult time, and there are going to be a lot of mental health issues come out of it. So I think employers should look at that type of article and say, what can I do in a COVID world to minimize the mental stress of my employees? And I think that's just a practical hands-on thing. When we're dealing with people working from home, you've got to figure out how you kind of alleviate some of the mental stress by connecting with your employees. That's the danger of people working from home. You don't connect with them. Hey, how you doing? How's the wife? How's the kid? Boom, 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 right? So I know some employers are really innovative in this. They're calling employees. They're having little, cocktail parties by Zoom and this, that, and the other. So there's ways in which you can do that. Don't lose sight of it. Now, back to the legal issues. Employers have a duty to inquire about mental stress and the rest of it. In this quote I give you from Mackenzie case, the Thrifties had a duty to inquire whether the behavior exhibited by Ms. Mackenzie was due to her mental disability and whether she required accommodation. They didn't fulfill that duty. They simply dismissed her because of behavior she exhibited: mood swings, irritability, being manipulative, which was consistent with the diagnosis of adjustment disorder and depression. Accordingly, I find part of the reason Ms. Mackenzie's dismissal was due to discrimination. Any issue of a bona fide occupational requirement and any accommodation of Ms. Mackenzie's disability cannot be answered under the duty to until the duty to inquire is satisfied. So, what you inquire, when you inquire, is a really practical question. But when you're doing a little checklist of, I wonder what we should do here, and especially if you've got a poor performing employee, there may be underlying reason. The employee that always misses Monday, may have an alcohol problem. There are just some telltale things. And again, you just have to be careful. Okay, I'm going to deal with discrimination on the basis of sex and sexual harassment. The Me Too era has created a greater awareness of sexual harassment in the workplace, of course, and thus such complaints are likely to be pursued more likely these days by victims. The public sting of the allegations can be devastating, especially if the complaints are false. And you're the owner of the business. You've been accused of sexual harassment. Well, again, you've got a problem because you may be right and you may be successful after a case, but the sting of the allegation is going to be significant. And the Me Too movement hasn't quite figured out how we protect the innocent employer. Employers must consider the practical issues of having a public hearing. Your complaint gets put on the website at a certain point and becomes public. So often these cases are dealt with earlier. Collateral actions come out of it, defamation, claims for aggravated damages. And I want to point out that employers are responsible for the actions of the employees. This isn't vicarious liability. You're responsible in large part because you're the one that can solve the problem, reinstating people, that type of thing. And class actions, these RCMP just paid $100 billion to get rid of sexual harassment. We know that WestJet, the flight attendants have brought systemic sexual harassment, sex discrimination complaint. And there was an application to dismiss the lawsuit, and that application was dismissed. So that lawsuit's going ahead. Okay, now I follow Tech Cole in the newspaper because a friend of mine was in-house counsel for Tech. And I remember when tech stock dropped to like $4 or $5, and I never got in. It got up to like $50. So I watch it every day. I don't know why. I just take a look at it. But it's pretty clear that tech stock has gone down substantially. So I kind of wonder, well, that may be a whole bunch of things. First of all, it may be that they're in a commodity market in a tough thing, so that's a problem. It may also be that having a name of Tech Coal Ltd. In an environmentally changing world, especially with the Liberals Party position, that may not be the best thing. So they may want to change of name. But the other thing may be they may want to limit the number of investigators they bring in to look at a complaint by a person who was employed for one day and then quit. Because in this case, I'm going to tell you, there were a lot of investigators. And the ultimate claim for the complainant will be allowed to proceed. So what happened here was the complainant claimed on her first day that she was sexually harassed. She saw lewd graffiti on a haul truck she believed was targeted at her. She fell in a company transport bus after the driver started to move away, and then the co-workers were making derogatory complaints or comments to her. Anyway, so Tech appointed an investigator. He quit, and then there was confusion at Tech as to what the heck happened. So they appointed 3 individuals to do an investigation. They interviewed 8 witnesses, found that the complaint was not well founded, that a reasonable person wouldn't have interpreted things as harassment. Then she goes to the CEO. CEO says, well, let me see if I can get somebody else to come in. So they brought in another investigator to look at the investigation. That external review found it was properly conducted. And so Tech said, sorry, we're dismissing, any complaint that you have. Unfortunately, the BC Human Rights Tribunal did not agree, and the matter was sent on. So the takeaway is that even with minor incidents, like a first day complaint, you got to be very careful because this can be very messy and very expensive. And here the investigation protocols were not well followed. So I've given the, what constitutes sexual harassment. I won't review it with you, but there is the test. And I think it's been expanded in part by the Me Too movement. At least that's what I've seen as to what constitutes sexual harassment. So next slide. The other thing that I think is interesting is that the complainant also named the manager of human resources. Fortunately, that complaint was dismissed against the manager, but it's something always to be careful about, okay? The other tip I'm going to give you just before we go on is that people will come in and say, look, I want to talk to you in confidence. I'm being sexually harassed by the owner. Well, you can't keep things in confidence. You have an obligation to look into these things. So you got to be careful before you promise that you'll keep things confidential. I'm just looking at the time here. So it's 5 to 12, and I apologize because we really do have way too much in here. I'm just going to leave the Weeze case, great clips, just an example of where it's a he said, she said situation. But it's an interesting case to see why the tribunal was able to find in the complainant's favor, looking at a bunch of other things other than just listening to the evidence of both of them. The employer denied it, the complainant said it happened. And so this is a maternity leave issue. So make sure you document things, et cetera. These ones, just another example of odd stuff. I mean, a manager leaving underwear, a bra, and a wig at a workstation. that's pretty good evidence that this thing is not going the right way. But there wasn't any touching or physical threats. Her hours were cut. She complained. Bottom line was they gave her $40,000 for injury to dignity, but only $8,000 in lost wages. She got another job. That's a big number. That's equivalent at a high tax rate to $80,000. So that shows the upward trend. Family status. And I wanted to raise this because there could be far, far more cases. And the one good news for employers under employment or human rights in BC is that our decision of the Court of Appeal of BC in the Campbell River case is a very restrictive interpretation of what discrimination on the basis of family status. And again, I won't read it to you, except to note that if somebody claims they're being discriminated against because, you know, they want to take care of their kid or whatever, they have a heavy onus to show that there is a substantial disruption to their circumstances. And so you can just read the test from there. And in this particular case, the person said, well, I need to be at home. I need to, you know, make sure my kids get the proper Slovakian heritage and language. And they said, no, you know, look, you could use babysitters, you can use daycare, you can use other family members, etc. And that restrictive definition of family status has been upheld recently by the Supreme Court of Canada in denying leave in the Sewin case. So other jurisdictions give a much broader scope to it. So if you're doing your own research and you see one that's, you know, broadly based, that may not apply here. So be very careful in relying on other cases from other jurisdictions. This one I put in because of me. I'm filing a complaint against Chris because this one, the complaint about discrimination on the basis of age, was because the owner allegedly said he was a grumpy older guy and an old man. So that case was dismissed. The Human Rights Tribunal said it wasn't so virulent or inherently damaging to his dignity. And they offer a number of cases where, you know, get real. The moral of the story is be careful when terminating curmudgeons. Next. And again, this is a good quote from the Jaffer case. I won't leave it, but just on your own pleasure, it speaks for itself. So here's the summary, folks. Be careful around terminations or discipline when possible human rights issues. Now remember, 5% of your employees will probably cause 95% of your problems. It won't be hard to identify who likely will cause the problem. Consider whether you should include reasons for termination, even where you're not alleging cause. I had a case where, you know, they weren't alleging cause. Common law doesn't require you to put in reasons if you're not alleging cause. But we then got hit with the human rights complaint. And if we had put more stuff in the termination, even though we weren't alleging cause as to why we did it, it would have been helpful. Anyway, so consider that. Ensure your documentation is ordered. You've heard that from Chris and I a lot. Follow your policies and procedures. You've heard Chris and I tell you to do that a lot. Don't just do a policy manual and put it in the desk and have it get dust. You know, if it's going to be a living document, it's got to make one that makes sense and follow it. Consider whether an outside investigator should be retained. There are, you know, I could do a whole seminar on outside investigators, and there are appropriate cases. I had Tom Beasley do a report for me in a sexual harassment case. It was outstanding, and I was able to solve the problem quickly. Other times they just get more complicated, and whether or not you could use them to defend yourself, tech found you couldn't. So they may have limited utility. Also, you have to be very careful about protecting issues of privilege. So if you have your lawyer doing an investigation, but also providing legal advice, all of that may be privileged. Otherwise, it may not be privileged. And so you get people getting into sensitive information. Educate your employees. I think that's a given. Don't be shy about it. Educate them. And remember, your employees are your most valuable asset. So if you want them to be productive, you have to know how to manage your environment. And finally, be proactive in addressing problems. Always ask yourself, what could possibly go wrong here? And always listen to that little guy who's on your shoulder whispering in your ear saying, oh, I don't know, this could be a problem. Anyway, that's everything that I know about human rights. We have gone right up to the bewitching noon hour. We will, I don't know if we've got any other questions here. Let me just take a look here.
There's one question. I think given the time we can probably get back to that person. What we'll do is we'll post the answer to everyone, so they've got it. So thanks very much, Mike. We'll put this recording up on our blog and send you the link. And if there's any other questions arising from people, feel free to get in touch with myself, Darlene, or Mike. Thank you, everyone, for bearing with us this morning and for joining us. It's our pleasure.